Welcome to Within the Frame, where we bring the most pressing issues across the globe into focus. I'm Kim Mok-yeon. The Trump administration is stepping up its immigration crackdown, and the impact is being felt far beyond undocumented migrants. The State Department says more than 175,000 visas have been revoked since President Trump returned to office, mostly over criminal activity, but also in cases involving birth tourism and certain political remarks. Now, at the same time, tighter screening and new visa rules are making it harder for some foreigners to enter, study, or work in the United States. So how far could these changes go, and what could they mean for Koreans heading to the U.S.? For more on this, we connect to Colleen Putzel-Kavanaugh, Associate Policy Analyst at the Migration Policy Institute. A very big welcome.
Thank you for having me.
And also joining us is Lee-Hyun, Dean and Professor of Law at Handong International Law School. Good to see you, Professor.
It's a pleasure to be on the program again.
So let's start a discussion first with the big picture, Ms. Putzel-Kavanaugh. So what is the overall direction of President Trump's second-term immigration policy? What's the administration ultimately trying to achieve?
Sure. I think to start, looking back at Trump's first administration, what we noticed was that he was largely focused on the border, primarily the southern border, and the main focus there was building a border wall. And that really consumed the first administration. And there were some changes or attempts at changes to the legal immigration system, but it wasn't as impacted. The legal immigration system under the first Trump administration was actually most impacted by the COVID-19 pandemic, as opposed to some of the changes or intended changes of the first Trump administration. The scale of changes this time around, however, can best be described as a death by 1,000 cuts. There are some of the large changes that we've seen, like a $100,000 fee for H-1B visas, the travel ban and processing ban for nationals of certain countries, and the unraveling of certain types of protection like temporary protected status. But there are also those small kinds of technical changes that on the surface may seem minor, but they actually really throw sand in the gears of regular processing, like necessitating in-person interviews, additional background checks, pieces that make the process more arduous for people who are applying. And then simultaneously, we see this administration has targeted those with valid visas who are already within the country, like foreign students. And that creates a much more hostile atmosphere, with the sort of undercurrent being the administration really encouraging self-deportation. So the ultimate goal really seems to be an overall lower levels of immigration to the United States, not just focused on irregular immigration or immigration at borders, but to the entirety of the system. People who are coming on valid visas to work, to study, or to travel. And so we see this as sort of an expansion of some of the attempts of the first administration to really get at other areas of our legal immigration system.
Right, so quite a bold gesture we're seeing during his second term. But from a legal perspective, Professor Lee, how much power does a president have to restrict immigration, visas, and entry into the United States? And where should the limits actually be?
Right. Well, I mean, the core principle in sort of U.S. law regarding immigration is that basically control over who can essentially enter the country is treated like an incident to national sovereignty and closely tied to foreign affairs and national security. And so in general, the U.S. courts have given, exceptional deference to the executive branch, in this case, particularly the president, when it comes to those kinds of matters, especially related to foreign affairs and national security. But in this case of sort of immigration generally, Congress has actually given authority to the president under, legislative act, which is this case, the Immigration and Nationality Act, and basically has essentially given a broad range of authority to the president with respect to immigration. And so, for instance, practically what this means is the United States, and the president particularly in his administration, can exclude non-citizens who have never entered into the United States and on a broad set of standards. And this has been given a lot of deference by the courts. So in the first Trump administration, there was a case that the Supreme Court basically said, there could be a broad travel ban. And basically using the national security logic as the basis for that. But also in terms of setting visa category caps, country-specific policies like temporary protected status, asylum procedures, these are essentially treated as discretionary policy that Congress and the executive can basically adjust. But I think what you've seen this year is a set of cases, big landmark cases related to immigration that with respect to, let's say, people seeking asylum, in the past, they could get to the border and be processed, or even before getting to the border. But a recent case in the Supreme Court said that you have to sort of literally arrive in the United States, and that means that it has to be at a particular entry point, and an immigration officer then can perform an inspection for those asylum seekers. But anyone else, if before you get to the border, can't seek asylum. But also, the United States Supreme Court has also said that with respect to temporary protected status for Syrian and Haitian nationals, that you basically you can get rid of those designations by the executive branch. And so I think what you're seeing here is that interplay between the courts and the administration, but also Congress, with respect to immigration policy. And that has really been, I think, at the crux of what these issues mean. But specifically when it comes to individual rights, I think we've seen cases where, like we said, with the recent case involving birthright citizenship, that case, of course, has been upheld and said basically the administration cannot eliminate that by itself, but also due process for people physically in the United States. Habeas corpus still is in effect. So I think what we're seeing here is that struggle, I think, between individual rights, but this really is a question about those within the country versus those who are not in the country at this point.
So it's really about the balance between government power and individual rights right here. But now actually we're seeing tougher approaches already in practice. More than, like I've said, 175,000 visas have been revoked since President Trump returned to office. Ms. Putzel-Kavanaugh, what stands out to you about the scale and the scope of these revocations?
Sure. The pace and the scale of visa revocations has certainly increased. So to draw a comparison, one estimate says that the Biden administration revoked around 40,000 visas total over 4 years. And already the State Department is reporting 175,000 visas revoked already in this administration, about a year and a half, almost 2 years in. On the grounds of revocation, the Trump administration is using existing law. What's different and what makes this, I think, more intense than we've seen during past administrations is that this administration has directed extensive resources and energy to this effort. They're relying on criminal conduct, which sometimes even includes just an arrest as opposed to charges. And so sometimes someone being arrested could provoke a revetting of their visa, even if charges weren't ultimately brought. They're looking at visa overstays. They're looking at instances of fraud, other security concerns, and they've expanded the scope of what a security concern means. If we think back to last spring and the targeting of specific foreign students based on their speech concerning the conflict in Israel and Palestine, and those sorts of cases have been broadened into national security concerns. And so this sort of systematic creation of consistent revetting, greater scrutiny of records like social media, and more heavy-handed enforcement have all led to this increase. But what we've seen is that not only is there sort of this increase in the number of visas revoked, but we've also seen a stretching of the reasons that visas are revoked, but they are within existing law. But what marks this as different is sort of the resources that are allocated to this revetting.
Well, certainly a significant expansion in terms of both scale and scope. And that tougher screening is now extending to the online world. Professor Lee, where should the legal line be drawn between reviewing social media for national security and protecting freedom of expression?
Right. So I think there needs to be distinction between those who are, let's say, applying to visit the United States versus those who are currently in the United States. So when it comes to the First Amendment of the Constitution that protects free speech, if you're a foreigner and you're trying to attempt to enter the United States, you don't get those protections of the First Amendment with respect to your social media pages. If you say something, let's say, and this is largely based, let's say, on, let's say, national security concerns, and you've said something against the United States, that speech is not protected by the First Amendment because you're outside the United States and you're a non-citizen. But there's another issue, though, of course, for those who are currently in the United States. And let's say you have a student visa, you're a green card holder, and then the question is, can your status be revoked somehow because you've said something, let's say, that is not favorable within the administration's viewpoint. But I mean, I think the question here goes to other issues. So when it comes to applicants, if you're applying for a visa, let's say from Korea to the United States, I mean, the United States is now putting its resources to look at those social media posts that you've posted, even those that you've sort of deleted and try to scrub, and they're going to look for things that are going to, let's say, indicate that you're potentially a threat to the security of the United States. And on those grounds, they can certainly reject your visa application. And generally speaking, consular decisions made by those at the embassy with respect to visas are not reviewable by the courts. And so basically, once you've been rejected on those grounds, you can't get a court to review those decisions. But I think that some of the big questions now in the United States that's really being litigated actively is, let's say, with respect to students, and let's say people on student visas or green card holders who are saying certain things on social media. And then the question is, can the administration go after those people and revoke their visas even though they're currently in the United States? And so that's the big question, because generally speaking, it's been a sort of a security screening view. That's the idea that, if they're a threat to national security, then generally, yes, you can eject someone from the United States. However, because if you have specific viewpoints that are not popular, let's say you're critical of U.S. allies, let's say like Israel, or you participate in a protest, that's, as opposed to being, say you're involved in terrorism or you're involved in some kind of violence, but you express a certain viewpoint that is, let's say, disagreeable, then that's the kind of issue and that's the kind of harm which I think the courts are going to weigh. And so these are ongoing cases. And really the honest answer here is there's not really been a clear line legally drawn between security concerns and screening versus some kind of viewpoint discrimination. And so I think that's the kind of that standards being kind of the issue that the courts are grappling with, and hopefully we'll get some sort of clarification from the courts as to whether or not visas can be revoked on those bases.
Right. So, Professor Lee, just to make just to check if I've understood the situation. So the current line is quite vague, both for people who are willing to go to the United States and both for people who are already in the United States. Did I get it right?
Right. So when you're entering the United States, if you're trying to apply for a visa, basically there's broad discretion to reject, right? But when it comes to people who are in the United States, there's been legal challenges as to whether or not you can be kicked out of the country because of some viewpoint discrimination. And so I think that there's the line between national security versus political views, I think, is the question that a lot of people are looking at in terms of the legal question that needs to be resolved.
Mm-hmm. Thank you for that clarification. So, so this situation is quite an important issue for international students. So from September 15th, F and J visa holders will move from duration of status to a fixed periods of stay. So Ms. Putzel-Kavanaugh, what should Korean students and researchers be most careful about right now?
Sure. This change is really emblematic of what I said before about sand being thrown in the gears of legal immigration. So now, as you said, F and J visa holders will have a fixed period of stay as opposed to a duration of status, which means there'll be sort of an end date on their visa. And this creates a lot of burdens. In order to stay, an F or J visa holder will need to file with USCIS, United States Citizenship and Immigration Services, to extend their stay. This adds extra application burdens, potential fees, and potentially extended processing times. Or an F or J visa holder could choose to depart and seek readmission with an updated document. but that means that their readmission would be under scrutiny. And we just described many of the layers of added and new scrutiny that comes for people trying to re-enter from outside the country. And so all of these new barriers really create increased administrative burdens and more opportunities for missed deadlines. And it has to be handled at a higher level than extensions previously had to be handled at. And so I think that for students and researchers, it really just means trying to, as best as possible, understand these new rules and understand the extra and added administrative burdens that come with them.
Right. So with this current situation, it's not really just difficult for students themselves. H-1B rules are also changing as well, we hear, including a wage-weight selection system and the disputed $100,000 fee for new overseas applicants. What could this mean for Korean professionals hoping to work in the United States, Professor Lee?
Right. So when it comes to this H-1B visa status, when it comes to instead of a lottery where it's kind of random and basically you're lucky if you get it, now it's going to be weighted towards those who get the highest wages versus, let's say, entry-level workers. So at some level, and then you mentioned the $100,000 fee, which courts have actually struck down, said you can't do that. The United States government cannot collect. So that this is being actually very much litigated. And so the government, U.S. government's trying to reimpose the $100,000 fee. So that really needs to be a wait and see approach in this question about whether that will actually be assessed and actually be collected from visa applicants. But this H-1B visa, in terms of the Korean professionals who are, let's say, trying to work in the United States, actually doesn't really affect Korean workers all that much, in the sense that a weighted system probably, I think, helps Korean workers and Korean applicants because they tend to be at the higher levels, right? Higher pay scales, highly skilled. The H-1B sort of, and this system now, as proposed by the Trump administration, and this weighted system actually discourages and makes it harder for lower level professionals from getting the visa. So if you're working for Samsung, LG, or Hyundai, and you're a high-level engineer, you have a higher chance to get this visa. But also in the Korean context too, because of the relationship between the United States and Korea, there's been actually some effort to try to exclude Koreans from this H-1B system by having a separate sort of track for Korean professionals. But that has not made its way through Congress yet, but there's been efforts to put a legislative fix on this problem. But regardless, I mean, there's a strong pathway for Korean professionals anyway, because a lot of Korean professionals don't come under the H-1B visa status. They come under some intra-company transfer visas, an L1, which is a different process and a different system that's not subject to the same rules and regulations of the H-1B. So in large part, I don't think this affects Korean professionals all that much, especially when it comes to people working at large corporations that are temporarily working in the United States.
All right, thank you for that. Now, there's also a interesting contrast here. So immigration rules are getting tougher, but the administration has also introduced a so-called gold card for wealthy foreigners. Ms. Putzel-Kavanaugh, what does that actually tell us about who the U.S. wants to attract?
Right. The Trump Gold Card requires a really hefty upfront fee of $15,000 and a $1 million gift to the U.S. for a fast-tracked visa. And it is, as you said, really emblematic of the overall tightening of immigration to the U.S. as it's unreachable by probably most of the population. And I think that by focusing exclusively on this sort of upfront gift of being able to provide $1 million to the U.S., it also really ignores the many contributions that all types of immigrants provide and have provided to the U.S. through research, in the workforce, in our schools, and in our communities. Data on the uptake of the Gold Card thus far indicates that it's not been broadly popular, and that may be by design. As of the spring, just 59 people had submitted a formal petition for a gold card, and there's been one approval so far. So I think that this, is obviously showing that there's a level of exclusivity that this administration is trying to develop within our immigration system, and one that's based on financial contribution alone.
So it's not really simply about restricting immigration, but also becoming more selective as well. So now to Professor Lee for our final question. So the administration, it doesn't have the entire final say on everything, of course. The courts are also weighing in on several parts of President Trump's immigration agenda. How far can they go in limiting the president's immigration powers?
Well, I think there's got to be I think there are two things to look at here. One is the sort of congressional authority under the Immigration Act that's been given to the president and given broad discretion. So when you look at the court's sort of history and recent history in terms of its decision making, I mean, the court has really given a lot of deference to the president when it comes to congressionally delegated authority with respect to immigration, right? When it comes to temporary protected status, limiting that for certain groups of people. When it comes to, for example, issues related to asylum protection and whether or not you have to be at the border, can you reject people at certain states, at certain levels with respect to their approaching the United States. So from that perspective, the court has clearly given a lot of deference. But when it comes to constitutional provisions like the 14th Amendment and the birthright citizenship clause, there the court has basically held the line and said, no, the administration, you can't go outright and try to eliminate that on your own. It's constitutionally protected. And I think that's where you see the distinction in some sort of pattern emerging with respect to this current court and this current term, is that in general, the line is held when it comes to constitutional rights in terms of guarantees under the Constitution. But when it comes to, again, congressionally delegated authority under the Immigration Act, there the courts have generally been seen to be more deferential to the president and given the administration a number of different wins in that space. So I think that's where I think people are going to be viewing the court going forward, is how the court then goes about then clarifying a lot of these issues, because these are not going to be over with, right? There's going to be more cases that are in the pipeline. I think the administration is going to test this even further by trying to push the boundaries as much as possible. But I think what we've seen is there's a line being held with respect to constitutionally guaranteed rights versus those that have been enacted by Congress. And really, in terms of real change to be had, really Congress, if needs to act in terms of counteracting the president and holding them to a tighter line when it comes to immigration policy. But that's a political question that needs to be resolved in the future.
Right, certainly a lot to watch, especially with a lot of non-Americans living and traveling and studying in the United States. But as for now, we'll have to leave our discussion here tonight. Thank you so much for your insights, Professor Lee.
Thanks for having me.
And of course, Ms. Putzel-Kavanaugh, we really appreciate it.
Thank you so much.
And that'll be all from us on Within the Frame. Thank you for joining us, and be sure to tune in again next time as we explore the stories that matter. Until then, stay informed and engaged.